and welcome to the 14th Annual Kosciuszko Chair Spring Symposium. The focus of this year's virtual conference will be Security, Faith and Resilience in the Intermarium and Beyond. Today's virtual symposium is organized by the Institute of World Politics. For those of you who are new, IWP is a graduate school of national security, intelligence and international affairs. We offer a doctoral program, 7 master's degree programs, including 2 online MAs, and 18 certificates of graduate study. If you are interested in learning more about us, please visit us at iwp.edu. We would like to thank all of our supporters who make our IWP events program possible. To support the work of IWP, please visit iwp.edu/donate. Today we'll be hearing from Mr. Marcin Romanowski on his lecture titled The Unlawful Detention of the Conservative Opposition MP. Marcin Romanowski is a Polish politician. He was the Deputy Minister of Justice in the cabinet of Mateusz Morawiecki. He was elected as a member of the Sejm on 15 October 2023 from the Law and Justice list. He's the first Polish political refugee since 1989. Please welcome Mr. Romanowski.
Thank you very much for having me again. Indeed, the lawlessness unfolding in Poland is unprecedented in its recent history, actually since the fall of communism. And it's crucial, I think, that you take an interest in it because exposing the abuses committed by Tusk's left liberal administration serve as a warning to others. Poland has unfortunately become a testing ground for the aggressive implementation of liberal autocracy. But similar actions have been taken or are being taken in France against Hungary. And let's not forget that Donald Trump himself has been a target of lawfare. And such actions will continue to be pursued by globalist forces in other countries. In Poland, the Tusk government continues to engage in unlawful activities to this day. A striking illustration of this is described in the criminal complaint filed by the president of the Constitutional Tribunal, Bogdan Święczkowski, on January 21st, 2025. This notification concerned the suspected operation of an organized criminal group involving Prime Minister Tusk and Minister of Justice Bodnar, aimed at committing offenses under Article 127 and 28 of the Polish Criminal Code, namely using force to alter the constitutional order of the state and using violence or unlawful threats to interfere with the functioning of constitutional bodies, including the Constitutional Tribunal, the National Council of Judiciary and the Supreme Court. These acts representing an attack on the very foundation of constitutional order are punishable of long-term imprisonment and even life sentences. Let us not overlook the fact that among the principal potential suspects are first and foremost Prime Minister Donald Tusk, Minister of Justice, and Prosecutor General at the same time Adam Bodnar, former Minister of Culture Bartłomiej Sienkiewicz, as well as other senior government officials, MPs and senators of the ruling coalition. The president of the Constitutional Tribunal accused them inter alia of deliberately undermining of the legality of Constitutional Tribunal's judgments and the status of its judges. of obstructing the functioning of the tribunal, of questioning the status of Supreme Court judges, for example, from the Chamber of the Extraordinary Review and Public Affairs, and of refusing to implement constitutional tribunal rulings by suspending the publication of its judgments in the official journal by the Government Legislation Center. The allegations contained in the notification were supported by witness statements, including from the presidents of the Constitutional Tribunal and the Supreme Court, the chairperson of the National Council of the Judiciary, and the chair of the National Broadcasting Council, which is a constitutional body responsible for media freedom. Preparatory proceedings were initiated by the Deputy Prosecutor General, Prosecutor Michał Ostrowski, who was independent of Tusk administration. The Prosecutor General Bodnar then unlawfully took over the case and initiated even criminal proceedings against Ostrowski himself. Nevertheless, the majority of the evidentiary proceedings were carried out. So these are key issues. However, in this lecture, I would like to focus on a specific matter, namely the events associated with the blatantly unlawful deprivation of liberty of opposition members of parliament. Not because of me, not because members of parliament should enjoy special privileges or hide behind immunity, but because allowing prosecution only with the consent of parliament ensures a degree of independence from the executive and judicial branches. The violation of this principle by Tusk's left liberal administration is more than just ordinary lawfare against conservative opposition politicians and the weaponization of courts and law enforcement. It's a show of force and a method of intimidation meant to warn ordinary citizens not to dare oppose the authorities. The message was clear. Look, we can unlawfully imprison even members of parliament, and no one can stop us. So what do you think we will do with you? So it was this clear message, and to a large extent, Tusk's administration has succeeded in intimidating society. It changed, but the first months of the Tusk administration was really full of fear and intimidation. The system in that time, the system of checks and balances between branches of government and institutions has been seriously undermined as they are being brought under the political control of the left liberal establishment. The entire apparatus of the state has been weaponized in a campaign of lawfare against the conservative opposition. The unlawful takeover of the prosecution service and the judiciary has subordinated the justice system to Donald Tusk's left liberal administration. I was myself unlawfully detained in July 2024. Earlier in January 2024, two opposition opposition MPs Mariusz Kamiński and Maciej Wąsik were also unlawfully imprisoned. I will only briefly mention my own case. I discussed it in greater detail in a previous lecture. First, the unlawfully appointed national prosecutor submitted in June 2024 a request the same for permission to prosecute and arrest me. I have previously addressed in a separate lecture the issue of how the prosecution was unlawfully and forcefully taken over. So you can see it. Well, in a properly functioning rule of law state, if I were ever suspected of any crime, I would, of course, voluntarily waive my immunity. But in this instance, I deliberately wished the MPs who voted in favor of the motion of to bear responsibility for participating in unlawful action. And so it happened, despite arguments raised that I was being pursued by an unauthorized authority, namely the illegally appointed national prosecutor, in addition to other objections regarding to the absurdity and illegality, in fact, of the charges. Marshal of Sejm, Szymon Hołownia, forwarded the motion to further proceedings, and the ruling coalition's MPs approved it. But the most serious violation of the law was my detention on July 15, 2024, despite being protected by another immunity, the immunity of the Parliamentary Assembly of the Council of Europe. Although I invoke this immunity, prosecutors unlawfully brought charges against me and deprived me of liberty. They justified their actions with two legal opinions commissioned by Deputy Minister of Justice Arkadiusz Myrcha, tailored to support the desired conclusion. It was only thanks to an unprecedentedly swift intervention of the president of the Parliamentary Assembly, incidentally a member of the same European People's Party as Donald Tusk, that I was released from custody. I felt several days after my release, I felt a criminal complaint regarding the conduct of members of the prosecutorial team, namely Piotr Woźniak, Marcin Wielgomas, Ryszard Pęgal, Andrzej Tomkarski, and Marzena Kowalska, who headed the prosecutorial team, as well as against National Prosecutor Dariusz Korneluk, appointed, as previously mentioned, in a violation of the law, and against Prosecutor General Adam Bodnar. The complaint also concerned the fabrication of legal opinions justifying the illegal detention involving Deputy Minister of Justice Arkadiusz Myrcha and the authors of the opinions, Joanna Juchniewicz and Andrzej Jackiewicz, professors from the Polish universities. Despite the multiple formal demands and even despite of 3 court rulings confirming the obvious illegality of my detention. Criminal proceedings were initiated only at the beginning of 2025. So when I had already obtained political asylum in Hungary, so the case has been internationalized, and the authorities, the Polish authorities, needed to create a facade of legality. A facade because the prosecution refuses to admit key pieces of evidence, primarily the content of email and WhatsApp correspondence, and the case was transferred from the Warsaw District Prosecutor's Office to the Internal Affairs Department of the National Public Prosecutor's Office, so that the illegally appointed national prosecutor could exercise tighter political control over the investigation. The fact that international law and Council of Europe regulations were violated is shocking, as is the systematic attempt to sweep this matter under the rug. What is increasingly overlooked by public opinion, however, is that at the very outset of Tusk's government in December 2023 and January 2024, a series of acts were committed that led to profoundly disturbing events, namely the unlawful termination of parliamentary mandates and the imprisonment of 2 opposition MPs, the former minister and deputy minister of the Interior in the Law and Justice government. Their imprisonment is, in my opinion, a textbook act of lawfare involving politicized judges from the Supreme Court and the regional court, combined with the blatantly unlawful actions of the Marshal of the Sejm and other officials, representatives of the ruling left liberal coalition. The origins of the case of Mariusz Kamiński and Maciej Wąsik, the 2 opposition members of parliaments, this case dates back over a decade, when the so-called first Tusk government initiated criminal proceedings against Mariusz Kamiński and Maciej Wąsik. The charges concerned actions they overtook in 2006-2007 while leading the Central Anti-Corruption Bureau, CBA. Kamiński as its head and Wąsik as his deputy at the time. They were the architects of this institution, which has been newly established during the first Law and Justice government, which took place 2005 to 2007. And the charges brought against them by the prosecution under Tusk's administration the first administration was between 2007 and 2015. These charges concern the so-called land exchange affair. The case stemmed from a special operation by the CBA, which suspected that prominent politicians from the then coalition partner party, Samoobrona, self-defense, were engaged in unlawful administrative practices, specifically in connection with decisions issued by the Ministry of Agriculture regarding changes to land use designations. As a part of the operation, undercover CBA agents engaged with public figures and made offers involving corruption, with the aim of obtaining evidence of criminal conduct. However, under the Tusk government, the public prosecution service determined that the operation was not a legitimate anti-corruption action, but rather an illegal provocation designed to artificially create a crime. According to the prosecutors, the CBA leadership had acted outside of the bands of lawful operations of intelligence services. The charges against Kamiński and Wąsik were based primarily on the Article 221 of the Polish Criminal Code, which criminalizes abuse of power by a public official. Under this provision, a public official who exceeds their authority or fails to perform their duties and thereby harms the public or private interest is subject to imprisonment of up to 3 years. In reality, these proceedings representing a form of political retaliation by the left liberal establishment that governed Poland from 2007 to 2015, targeting individuals who had built and successfully led the newly created anti-corruption agency during the 2005-2007 conservative administration. On March 30, 2015, the first instance district court for Warsaw-Śródmieście found that the CBA leadership had overstepped their authority by initiating an operation in violation of procedural regulations and directing covert activities at individuals against whom there was, according to the court, insufficient basis for suspicion. The district court sentences both Kamiński and Wąsik to 3 years of unconditional imprisonment and imposed a 10-year ban on holding public office. The judgment was appealed and had not yet become final when the president of the Republic of Poland, Andrzej Duda, exercised his constitutional clemency power and issued a pardon in the form of individual abolition. This should have brought the case to an end. However, this event triggered a years-long constitutional and procedural dispute that lasted until 2024 and culminated in the unlawful detention of the two MPs for several weeks. So, on November 16, 2015, President Andrzej Duda, acting under Article 139 of the Constitution of the Republic of Poland, granted a pardon to Mariusz Kamiński and Maciej Wąsik. The pardon took the form of an individual abolition. That is, it was issued while the criminal proceedings were still ongoing and before a final judgment had been issued. As a result of the exercise of the clemency power, the criminal proceedings against both politicians were discontinued. Article 139 of the Constitution states the President of the Republic of Poland shall have the power of clemency. This power shall not apply to individuals convicted by the state tribunal. So, giving the wording of this constitutional provision, this form of clemency had not previously been questioned in Polish legal practice, neither with regard to its admissibility nor its procedural consequences. The right to pardon in the form of individual abolition was regarded as an expression of the President's constitutional prerogative to intervene in criminal proceedings at any stage. Moreover, the practice of general abolition carried out by means of an act of parliament has never been contested. This interpretation was consistent with the established constitutional practice and had not raised objections from judicial bodies or legal scholars. Following the Act of Clemency on March 13, 2016, the Warsaw Regional Court, reviewing the appeal from the District Court judgment, recognized the presidential pardon as valid and effective. On that basis, it overturned the previous conviction and discontinued the criminal proceedings against Kamiński and Wąsik. The legal basis for the discontinuation was Article 17, Section 1.11 of the Code of Criminal Procedure, which precludes criminal prosecution where there exists another circumstance excluding prosecution, in this case the presidential pardon. In this legal and factual state, the case was definitely closed. Neither defendant was lawfully convicted, and the proceedings against them were officially discontinued. Only later, was the effectiveness of this form of clemency questioned by the Supreme Court in what became the first such instance in the history post-1989 Poland, despite the fact that it had no grounding in the constitutional understanding of the clemency prerogative of the President of Poland. So, following the judgment of the Warsaw Regional Court of March 2016, which, due to the exercise of the President's clemency power, discontinued the criminal proceedings against Mariusz Kamiński and Maciej Wąsik, a cassation appeal was submitted to the Supreme Court by legal representatives of the auxiliary prosecutors. This action initiated a series of politically motivated moves by judges aligned with left liberal circles, actions that violated the constitution, particularly by unjustifiably contesting the president's constitutional prerogative. In the course of this proceeding, on February 7th, 2017, the Supreme Court referred a legal question to a panel of 7 judges of the Supreme Court. The question concerned whether the president might exercise the power of pardon before a final conviction has been issued, that is in the form of an individual abolition, and what legal consequences would result from a potential overreach of this prerogative. In response, on May 21st, 2017, the Supreme Court, sitting in a 7-judge panel, adopted a resolution stating that the power of clemency might be exercised solely with respect to person whose guilt has been confirmed by a final and binding court judgment. So the resolution was issued by the panel composed of judges Jarosław Matras, presiding and reporter. In the panel Jerzy Grubba, Dariusz Kala, Przemysław Kalinowski, Zbigniew Puszkarski, Dorota Rysińska, and Barbara Skoczkowska. What is interesting that no dissenting opinions were submitted, indicated that none of the panel members formally objected to the decision, despite its clear inconsistency with the president's constitutional prerogative. As mentioned, Article 139 of the Polish Constitution states that the President of the Republic of Poland shall have the power of clemency. Point. This power shall not apply to individuals convicted by the state tribunal. So that's all. And in this regard, the Supreme Court's resolution constitution departure from the previous legal and constitutional practice, which had recognized the president's ability to intervene in criminal proceedings at any stage, including prior to a final judgment. By issuing this resolution, the Supreme Court challenged the effectiveness of the Clemency Act issued by the President in November 2015, including that it could not produce legal effect if issued prior to a final conviction. The Supreme Court's position led to a constitutional dispute. Consequently, on June 8, 2017, the Marshal of the Sejm submitted an application to the Constitutional Tribunal for the resolution of a competence dispute between the President and the Supreme Court. According to the applicable law, the filing of such an application automatically suspends pending proceedings. It's Article 86 of the Act of the Constitutional Tribunal. Despite the legally binding suspension on February 28, 2023, the Supreme Court decided to resume cassation proceedings. According to the Constitutional Tribunal, this action constituted a flagrant violation of the law and contradicted to the constitutional principle of the rule of law, stated in Article 2 of the Polish Constitution. Subsequently, on June 6, 2023, the Supreme Court overturned the 2016 judgment of the Warsaw Regional Court, which had legally discontinued the proceedings on the basis of the pardon, and referred the case for reconsideration. This judgment was issued by a panel of 3 judges from the Supreme Court: Andrzej Stępka, presiding, Małgorzata Gierszon, and Piotr Mirek, who was a reporter. Once again, there was no dissenting opinions filled in the judgment. As a result of that ruling, on December 20, 2023, the Warsaw Regional Court issued a renewed judgment convicting Mariusz Kamiński and Maciej Wąsik, sentencing both to 2 years of unconditional imprisonment and imposing 5-year bans on holding public office. The judgment was issued by judges Anna Bator-Ciesielska and Grzegorz Miśkiewicz, also without dissent. So it must be emphasized that this judgment was issued after the Constitutional Tribunal had on June 23, 2023, had reaffirmed the President's prerogative, ruling that the clemency power is the exclusive and non-reviewable competence of the President of the Republic of Poland, producing final legal effects. So the Supreme Court has no authority to review or invalidate the exercise of that competence. Thus, the judgment issued by the Warsaw Regional Court was in direct conflict with the Constitutional Tribunal's ruling. which under the Constitution is universally binding and final. It's Article 190 of the Polish Constitution. So both the 2017 resolution of the Supreme Court and its subsequent actions in 2023 were deemed by the Constitutional Tribunal to constitute a gross violation of the constitutional legal order, primarily due to attempts to interfere with the exercise of the president's prerogative and the disregard of the suspension of proceedings resulting from a pending competence dispute. This unlawful actions of the judiciary were followed by a further violation of the Constitution by the Marshal of Sejm, Szymon Hołownia, elected in autumn 2023 by the left liberal parliamentary majority. Despite the binding act of clemency issued by the President of the Republic of Poland on November 16, 2015 in favor of Mariusz Kamiński and Maciej Wąsik, and despite the ruling of the Constitutional Tribunal confirming the effectiveness of that presidential prerogative, Marshal of Sejm Szymon Hołownia issued on December 21st, 2023, a formal decision declaring the expiration of both MPs' parliamentary mandates. He acted with full awareness that the prior clemency measure rendered it legally impossible to deem that a final conviction had occurred, and an essential precondition for the termination of a parliamentary mandate. The political motivation behind the Marshal's actions, despite his constitutional duty to safeguard the rule of law and the independence of parliamentarians from unlawful influence by other branches of power, this motivation is evidenced by the extraordinary haste. So one day, with which he acted, issuing the decisions merely a day after the court ruling. The President of the Republic formally addressed the Marshal of Sejm, reiterating the legal effectiveness of his act of clemency and its consequences, clearly stating that no grounds existed to declare the expiration of the mandates. This letter was ignored, and the decisions were formally delivered to both MPs on December 28, 2023. On the next day, on December 29th, 2023, MPs Kamiński and Wąsik submitted appeals against the Marshal's decisions. In their submissions, they explicitly stated that the competent body for adjudication was the Chamber of Extraordinary Review and Public Affairs of the Supreme Court, which is in accordance with Article 26 of the Act of the Supreme Court. The appeals were filed via the authority that had issued the challenge decision, namely the Marshal of the Sejm. In such cases, if the authority does not reverse its own decision, it is obliged to forward the matter to the competent appellate body. Despite this obligation, the Marshal of the Sejm referred the appeals to the improper Chamber of Labor and Social Insurance of the Supreme Court, bypassing the Supreme Court's Central Registry Office and moved the appeal to the incompetent body. It was a move the Constitutional Tribunal later deemed unlawful and contrary to the principle of the rule of law. Notably, the appeals were physically delivered to the Supreme Court by Stanisław Zakroczemski, Director General of the Marshal's Cabinet. He bypassed the Supreme Court's registry and handed them directly to the President of the Labour Chamber. By order of that president, the case was registered in a Labour and Social Insurance Chamber, despite the fact that the appellants had correctly addressed their appeal to the Chamber of the Extraordinary Review and Public Affairs. This procedural irregularity was politically motivated. At that time, the president of Labour Chamber, Piotr Prusinowski, was closely aligned with a group of politicized judges sympathetic to the left liberal ruling bloc. In the matter of Maciej Wąsik's appeal on January 4th, 2024, Supreme Court Justice sitting in the Labour Chamber issued a decision in which, following the clear statutory regulation, he recognized the Labour Chamber's lack of jurisdiction and referred the case to the competent Chamber of Extraordinary Review and Public Affairs. Independently, in view of the unlawful actions of the Marshal of Sejm, both Maciej Wąsik and Mariusz Kamiński also filed their appeals directly with the Supreme Court. These appeals were duly registered according to proper procedure. On January 4th and 5th, 2024, the Supreme Court, sitting with statutory authority in the Chamber of Extraordinary Review and Public Affairs, annulled the decisions of the Marshal of Sejm, holding that there existed neither formal nor substantive legal grounds for declaring the expiration of the mandates of Mariusz Kamiński and Maciej Wąsik. The court especially emphasized that the 2015 Presidential Act of Clemency nullifies the effects of any conviction ex tunc, and that criminal conviction alone does not automatically result in loss of electoral eligibility under the Constitution to electoral code. Nevertheless, Marshal Szymon Hołownia publicly stated that he had addressed his correspondence to the Labor and Social Insurance Chamber and was awaiting responses from that chamber in both cases. Despite the binding nature of the Supreme Court's decision, the Marshal of the Sejm did not restore the MPs to active mandate status. On January 5th, 2024, he ordered the deactivation of their parliamentary voting cards. As of January 25th, 2024, he physically prevented them from entering the same chamber to participate in legislative sessions. In the case of Mariusz Kamiński's appeal against the Marshal decisions, which, contrary to legal procedure, had been hand-delivered by the head of the Marshal's cabinet, Stanisław Zakroczymski, directly to the Labour Chamber, the matter was nonetheless reviewed on January 10th, 2024 by a panel of 3 judges, Bogdan Bieniek, presiding, Jolanta Frańczak, she was a reporter, and David Miąsik. This panel of judges from the Supreme Court Labour Chamber, again without an dissenting opinion, rejected the appeal, asserting inter alia that the Marshal's decision was valid and that the December 20, 2023 conviction by the Warsaw Regional Court automatically triggered the expiration of the mandate. In doing so, the Supreme Court judges breached statutory and constitutional law. Together with the Marshal of Sejm, they brought about the effective and unlawful deprivation of 2 elected MPs of their parliamentary mandates. The actions of the Supreme Court justices and the Marshal of the Sejm were unequivocally deemed by the Constitutional Tribunal to constitute gross violations of the law and an assault on the constitutional composition of the Sejm, thereby undermining the legality of its subsequent legislative activity. The Constitutional Tribunal, in assessing the actions of state authorities toward members of parliament, Mariusz Kamiński and Maciej Wąsik, issued a definitive constitutional interpretation of the nature of the presidential power of clemency and the permissible scope of interference by other branches of government in its exercise. The tribunal held that the power of clemency enshrined in Article 139 of the Constitution of the Republic of Poland is an exclusive, personal and non-reviewable prerogative of the President of the Republic. This is a sovereign competence exercised solely by the President without the involvement of any other authority and without the need for counter signature of the Prime Minister. It follows that no institution, especially a court, has the right to assess the validity or merits of an act of clemency, regardless of its form, including individual abolition in that case. Consequently, the actions of the Supreme Court, which throughout its 2017 resolution and 2023 judgment, questioned the effectiveness of the 2015 Clemency Act, were deemed by the tribunal to constitute gross violations of Article 139 of the Constitution and infringements of other constitutional principle, the democratic rule of law state, Article 2 of the Constitution, the principle of legality, Article 7, the separation of powers, Article 10, and the universality and finality of constitutional tribunal rulings, Article 190 of the Constitution. The tribunal confirmed that the Chamber of Extraordinary Review and Public Affairs of the Supreme Court was the sole competent authority to adjudicate the appeals filed against the Marshal of the Sejm's decisions declaring the expiration of parliamentary mandates. The rulings issued by that chamber on January 4th and 5th, 2024, annulling the Marshal's decisions, were final, binding, and legally effective. So the Marshal of the Sejm was obliged to comply with them. Instead, as the tribunal found, the Marshal of the Sejm ignored the binding rulings of the Supreme Court, submitted for publication in official gazette Monitor Polski the decision declaring the expiration of Mariusz Kamiński's mandate, even though it had already been annulled by the court. And he filed to reinstate the MPs to the exercise of their parliamentary mandates. These actions were assessed as manifestly unlawful and as constituting active violation of the constitutional legal order. In the opinion of the Constitutional Tribunal, the actions of the Marshal of the Sejm described above led to a breach of the constitutional composition of the Sejm of the Republic of Poland, as defined by Article 96 of the Constitution, which states that the Sejm consists of 460 deputies. Two of them, Mariusz Kamiński and Maciej Wąsik, were unlawfully excluded from the chamber, resulting in a factual reduction of its composition. As a consequence, the Sejm proceeded with legislative deliberation and votes in an unconstitutionally constituted body. In the tribunal's view, this led to the invalidity of laws and resolutions adopted during that period. The tribunal stated that legal acts passed by the Sejm under these conditions were afflicted with a constitutional defect, having been adopted through votes conducted in an improperly composed legislative body. The unlawful imprisonment of MPs Kamiński and Wąsik lasted over 2 weeks. During that time, public protests erupted across the country in opposition to the government's abuse of power. The detained parliamentarians initiated a hunger strike. At the very outset, President Andrzej Duda, acting on humanitarian grounds, initiated a second clemency proceeding, despite his consistent and publicly stated view that the 2015 Clemency Act remained fully effective and that all subsequent actions by judges, the Marshal of Sejm, and other official and state agents were unlawful. The procedure, including the transfer of case files and the opinion of the Minister of Justice, lasted 2 weeks. During this time, the Minister of Justice declined to use the statutory opinion to suspend the execution of the sentence, despite the president's formal request. On the final day of Mariusz Kamiński's imprisonment, he was subjected to a painful forced feeding procedure, despite documented medical contradictions, an act that must be classified as a torture. So, in conclusion, it can be stated that the unlawful detention of myself, as well of MPs Mariusz Kamiński and Maciej Wąsik, constitutes a blatant and politically motivated violation of the law. These actions served as a show of force and were clearly intended to intimidate the political opposition and the broader citizenry. The aim was to suppress non-liberal political activity by sending a clear message, a clear signal. Even elected members of parliament protected by immunity could be subjected to arbitrary and groundless state repression. Throughout 2024 and 2025, these repressive tactics have continued under Tusk's administration in the form of prolonged pretrial detentions accompanied by violations of rights and degrading inhuman treatment aimed at coercing false testimony against political figures. In several of this cases, even the ombudsman, generally affiliated with the left liberal camp, was critical, issued critical reports. And the European Court of Human Rights has accepted cases concerning allegations of torture for adjudication. There have also been instances of state-led persecution targeting individuals with no political affiliations, whose only offense was criticizing in social media against liberal public figures. The actions of Tusk's left liberal administration follow the classic autocratic playbook. Repression of opposition politicians is merely the prelude to the dismantling of freedom of speech, freedom of media, and ultimately to the persecution of ordinary citizens. And so I have presented to you yet another area of lawlessness carried out by globalist forces in Poland, with the silent or at times open approval of central EU institutions. So thank you very much for your attention. I hope to see you next time. Thank you very much.